Welcome back to another edition of Between Two Fars. I'm Warneke Miller. We've been talking with Judge Reid Prouty, a Vice Chairman at the Armed Services Board of Contract Appeals, and we're going through concepts of attorney-client privilege and attorney work product and how it comes to light during litigation. And one of the issues we'd really like to focus in on is privilege in the context of government contractors. Can we just generally talk about these badgeless societies, these integrated workforces where you're working shoulder to shoulder with a contractor and with civil servants? And now we've got a contract administration issue that might ripen into a dispute one day. But as an attorney, we're still kind of wondering, where are the lines? How do we handle this with attorney-client privilege and discoverable material in mind for the distant future?
Sure.
Any thoughts or concepts on that you'd like to share?
When you first told me the question was about attorney-client privilege between NASA attorneys and government contractors, so that was a trick question. Because of course, you don't have a privilege between yourself and somebody who's not your client, and the contractor is not your client. And I understand in badgeless society it's a little bit different because they're integrated into your workforce. And the only advice I can give you, and it's going to be very bland and not very helpful, is that the same rules apply at the board as apply anywhere else, which is that if it is not your client you're sharing it with, it's kind of hard for it to be attorney-client privilege. And there may be ways under attorney work product, but we'd have to see what the law was, we'd have to see what was argued, and we'd have to look at on a case-by-case basis. And just as I said earlier, that the law is not always as clear-cut in discovery as you might think about what attorney-client privilege and attorney work product privilege is. I would suspect that would apply equally well to the case of divulging things to a contractor. So sorry,
No.
but it's just the way it is.
Yeah, we've talked about this before, and internally, we know that if an individual comes to us for legal advice and they're wearing a contractor badge, we have to send them back and ask them to coordinate with their civil servant and have their civil servant come and talk to the NASA legal office. We've also had times, and if you're newer to the agency and haven't experienced this before, where we may be sitting in a meeting that has got a large mix of contractors and civil servants, and when it comes time for the attorney to render the advice on the situation, we need to ask the contract employees to leave the room. And we need to sit down and just talk with the government employees and let them know that they don't need to be sharing this discussion outside the room. This is very difficult in the badgeless society because it is not to be offensive to the contractors. It is not to marginalize their involvement in our projects or their importance or their skill or expertise. But the truth of the matter is, if we are trying to decide what the government's going to do in a legal situation, and we want these discussions and these decisions to be protected if litigation is to ensue, we do need to take it upon ourselves as the attorneys to make sure we're sharing the information with the appropriate government individuals, and that is all. This is a continuing situation, and there's no clear answers, but it is nice to kind of hear from a judge that, hey, just reminding you, there's no attorney-client privilege with contractors. So this is a relatively short but important episode, and we appreciate your time and your insight on all of these sticky attorney-client privilege issues, which I know are your personal favorites, right? Every judge loves to get an attorney-client privilege dispute in front of them. All right, well, we're not done talking with Judge Prouty, so just hang with us and join us for the next episode of Between Two Fars.